I'll start again. I'm the 24th Regent of the Mount Vernon Ladies Association, Dee Dee Peachfry from the state of Wisconsin, and it is wonderful to welcome all of you this evening to this sold-out event on a timely discussion of the U.S. Constitution and George Washington. The Mount Vernon Ladies Association has owned and managed George Washington's Mount Vernon since 1858. A mere 50 years after Washington's death, this great historic site was nearly lost forever. Washington's descendants could no longer maintain the estate, and neither the federal government nor the Commonwealth of Virginia wanted to help out. To the rescue, a band of women who committed to do what the feds and the Commonwealth had refused to do, namely to rescue the home of our first president. They raised $200,000, and the rest, as we like to say, is history. From the beginning, the Mount Vernon Ladies Association was united by one cause: preserving Mount Vernon and educating the world about the character and leadership of George Washington. The association's goal was to focus on George Washington as a way to unite Americans. Hence, the association was entitled the Mount Vernon Ladies Association of the Union, and this was prior to the Civil War. Our mission was to be above politics, and that has been our ruling ethos ever since. Even during the tumultuous years of the Civil War, the Ladies Association ensured that both Union and Confederate soldiers could pay tribute to General Washington after laying down their arms. General Winfield Scott issued Order Number 13, declaring the estate's status as nonpartisan. Such actions ensured that Mount Vernon remained neutral, respected grounds. George Washington is the only president who was not the leader of a political party. In his farewell address, he warned Americans to focus more on the interests and values that unite us and to resist those who would cause strife. So in being strictly nonpartisan, the association is not only living up to the vision of our early founders, but emulating one of George Washington's important legacies. In true Washington spirit, we seek to be a place of civil discourse where people come together to listen and learn from the example of George Washington. That is why we are delighted to host this conversation this evening. And I hope you won't leave without looking at the rare ratification copy of the Constitution which is on display. I hope you will also go home and take a look at George Washington's own copy of the Constitution, which we have in the vault, securely protected. It is one of my favorite books since Washington did something he rarely did. He wrote in the margins. He annotated his role and responsibilities as president with care. So with that, let me turn this over to Allison Wickens, our Vice President of Education, who will introduce the History Teacher of the Year. Thanks so much for coming.
Thank you, Madam Regent. I am thrilled to be joining today to share this wonderful things that are happening in the classroom at Mount Vernon. As you know, we have a twin mission here at Mount Vernon: preservation and education. And one of our team, achieves great things in education because the teachers all across the country that are partners in bringing George Washington's story to their classrooms. And it is with great excitement and enthusiasm that I'm here to present the Mount Vernon History Teacher of the Year Award. It goes to one teacher in the greater Washington, D.C. area who brings both creativity and passion to their teaching, who generates a love of learning and deepens their students' understanding and appreciation of history. The award winner receives a cash award of $5,000 and a field trip to Mount Vernon for their students. The award runner-up receives the award of $500 and a virtual field trip to Mount Vernon. This year marks the 17th anniversary of the Mount Vernon History Teacher of the Year Award, and we are pleased to honor two very deserving local teachers. This year's runner-up is Kevin Curtin, a social studies teacher at George C. Marshall High School in Falls Church, Virginia. Please join me in congratulating Mr. Kevin Curtin. I tell you, Kevin's accomplishments are amazing, and reviewing his resume and the accounts that we heard from his peers and his students, and it just elevates how amazing our winner is this year, to beat out even Kevin's great accomplishments. Or should I say Mr. Curtin? Yes. This year's Mount Vernon History Teacher of the Year is Allison O'Connor. She is a 6th and 7th grade history teacher at Sterling Middle School in Loudoun County. She is an enthusiastic educator determined to create memorable experiences for her students while challenging them to think critically and practice extensive historical inquiry. She is a teacher who's always asking questions. Within Mrs. O'Connor's nomination materials, she says, "My goal as an educator is to have students realize that everything has a history, that primary sources are how we get to time travel, and that history class is where you can practice your thinking skills and ask the tough questions." Oh, those little 6th graders asking tough questions. It's amazing. It is clear that Ms. O'Connor is dedicated to history education outside of the classroom and to supporting her fellow educators. She is an active member of Creating Cultures of Thinking, an LCPS teacher learning group that focuses on building community around student thinking. She also serves as a K-12 teacher curriculum designer at the College of William and Mary, and she's a master teacher for our colleagues at the Jamestown Yorktown Foundation. Both of these roles focus on designing effective, innovative, and practical professional development for social studies educators. In a letter of recommendation for the award, a colleague wrote about her, "Allison is a dedicated educator who fosters historical inquiry and critical thinking and student engagement through these innovative practices. She is deeply committed to fostering her students' love of the subject. Her ability to nurture historical curiosity while also equipping the students with analytical skills ensures that her influence extends far beyond their time in the classroom." Would you all please join me in recognizing the 2025 Mount Vernon History Teacher of the Year, Ms. Allison O'Connor. Thank you for letting me steal a little time tonight to honor these teachers that give themselves every day to the future of this nation through their teaching. Thank you, Kevin. Thank you, Allison. And now I'd like to turn things over to Dr. Lindsay Chervinsky to get us started on this evening.
Nothing like starting with a little comedic humor to start the evening. Hello, everyone. Thank you so much for being here tonight. You know, as we were thinking about what would be a good program to honor our fabulous teachers, I couldn't help but think tonight would be a perfect night, because tonight is all about learning about the Constitution and, critically, how so many of us actually don't know enough about it. So who better to celebrate than those who are actually doing this work? For those of you who I don't know, I am Lindsay Chervinsky. I'm the Executive Director of the George Washington Presidential Library. Do we have any first-time visitors here at Mount Vernon tonight? I love seeing new hands. Welcome. Thank you so much for being here. A couple of logistics before I introduce our phenomenal panel this evening. As you've been seeing the slides go through, we have a number of events coming up that I would love to turn your attention to. Tonight's event is part of our Ford Evening Book programs. They are free programs that we offer every month thanks to the Ford Foundation. They make it possible for us to bring in amazing speakers to share their work with you, and we wouldn't be able to do programs like this without them. So please do check out our website for those free events. We also offer lunchtime events, and one of our big events coming up will be in the beginning of November. If I'm remembering off the top of my head, November 6th and 7th and 8th, somewhere around there. We have our George Washington Symposium. This year will be the American Military at 250. So we really encourage you to sign up for those events. We'd love to have you back for your second or 200th visit to Mount Vernon. We are also using a QR code system tonight, and we do this so that you can be involved in the conversation. If you've never used it before, you take out your phone, pull up the camera app, and hold it up to the screen. It will, using this QR code, take you to a website, and you can do that now or at any point throughout the evening. It will load your questions into the queue. You can vote on other people's questions, so it brings in a little bit of a collaborative feel to our discussion. And those questions will all be funneled into an iPad, which our wonderful moderator, who I will introduce in a moment, will have access to. The purpose of tonight's event is really to celebrate the Constitution more broadly, but also to celebrate the document that we have out in the lobby for you to see. And if you haven't seen it, I do hope you will check it out on the way out this evening. This Constitution is one of about a 100-copy print run. So only 100 copies were printed in New York City by John McLean for Dunlap and Claypool, which was one of Washington's preferred publishers. When he went to publish his farewell address, he also published it with Claypool. What makes this item so special is that a number of those copies were signed by Secretary for Congress Charles Thompson, and he signed them in the bottom, and then those signed copies went to the states for ratification. So that was the document that they were using long before the era of you could kind of, like look up on the internet what the bill was or study the text. You had to actually have it in front of you, and that was the copy they were using to determine ratification. So we believe that this is the only one that is in private hands. We are thrilled that a donor has lent it to us to be able to share with you. It will be a very essential part of our founding documents showcase in our new education center, which will open in the spring. But this is the first time that it is on public display since the auction, and so we are so lucky to have it. We'll talk a little bit more about it tonight, but I wanted you all to have that context for the document and why we felt it was important to have an event for it. One of my favorite parts about this job is when something like that happens, when we have this amazing document, then I get to say, who do I want to come talk about it? And they so often say yes, which is such a treasure. So the people that said yes to me tonight, which I'm so grateful for, starting with, most of them probably will need no introduction to you, but nonetheless. Judge J. Michael Luttig served on the U.S. Court of Appeals for the Fourth Circuit from 1991 to 2006. He was appointed to the federal bench by President George H.W. Bush. He served as the Assistant Attorney General at the U.S. Department of Justice and Counselor to the Attorney General for the United States. He was also Assistant Counsel to the President at the White House from 1981 to 1982. I'm now going to editorialize a little bit. This is the stuff you do not find on the Wikipedia page or on his bio. He is a legend among conservative circles in the legal field and is seen as the highest point of conservative principle in the law field. And so we are so grateful that he is here tonight to share his wisdom. Next, we have Congressman Jamie Raskin, who represents Maryland's 8th Congressional District. We were not sure he was going to be able to come, as you may have been paying attention to the news. So we are in some ways grateful that things are maybe not going as they ought to, and he's here with us instead. I think we're a much more fun group of people to spend time with. No, of course, insult intended to your lovely colleagues. Before being elected to Congress, he was a 3-term state senator in Maryland, where he served as Majority Whip. Previously, Representative Raskin was a professor of constitutional law at American University's Washington College of Law for more than 25 years. So we have really unbelievable brains when it comes to constitutional law here tonight, and we are thrilled. He is the author of several books, including the Washington Post bestseller Overruling Democracy, the Supreme Court versus the American People, the acclaimed We the Students, Supreme Court Cases for and About America's Students, and the New York Times #1 bestseller Unthinkable, Trauma, Truth, and the Trials of American Democracy. Kimberly Wehle is an expert in constitutional law and the separation of powers. She is a professor of law at the University of Baltimore School of Law, where she teaches con law, civil procedure, administrative law, and federal courts. She is a legal contributor for ABC News and Zateo, so if you see her face and it looks familiar, that might be why. And she regularly writes for Politico, The Atlantic, and The Bulwark, which I also love to write for, and I believe the judge has also written for, so we have a little bit of a theme going here. She was an assistant United States attorney in the Washington, D.C. office and associate independent counsel in the Whitewater investigation. She is also a number of books that I think are among the best in understanding the Constitution if you are not a lawyer, because she writes and talks like she is not a lawyer, which I love lawyers. My father's a lawyer, my brother's a lawyer, my husband's a lawyer, but they don't always make a ton of sense to non-lawyers. And so her books, What You Need to Know About Voting and Why, How to Read the Constitution and Why, and How to Think Like a Lawyer and Why, are phenomenal. Her most recent, Pardon Power, How the Pardon System Works and Why, won the 2025 Silver Award in the Political and Current Events category, and it is really excellent in understanding one of the most unlimited presidential powers in the Constitution. I put together this group and I thought, man, that's a lot of big brains and probably some strong opinions. Who can corral them? And one name immediately came to mind. Robert Costa is a national correspondent for CBS News Sunday Morning and chief Washington analyst for CBS News. His work on Sunday Morning includes coverage of national politics, in-depth interviews with newsmakers, and features on culture, literature, and the arts. He was named a national correspondent for Sunday Morning in February, following 3 years of contributions to the broadcast, including an exclusive sit-down in the White House with President Joe Biden in August 2024. He is also the author of a number of wonderful books himself, and all of these will be available for sale afterwards. I usually give my pitch about supporting small businesses at the end, but I'm going to ask you to do that now. And I should also say that I have done a number of events. I have been on a number of panels with people who ask questions, and Robert Costa is among the best at his business. So with that, will you please join me in welcoming them to the stage?
We have assigned seats.
I have no idea.
So, do we have assigned seats?
So when the time comes, we'll just pop up the questions and pop it there.
Can everyone hear me? Keep it clean on the questions. We're at Mount Vernon. It's wonderful to have you all here tonight. Thank you for coming out to celebrate the Constitution. And it's such an important topic in all times, but especially perhaps these times. And I'd like to begin, first of all, let's have a round of applause for this esteemed panel. What a great group. We're all lucky to be here. I feel lucky to be here. But I'd like to actually begin with our historian, Dr. Chervinsky, who did not introduce herself. She is an acclaimed historian, leader here at Mount Vernon, of course, and someone who is a real dynamic voice. It helps CBS News a lot, among other news organizations. So I thought, Lindsay, if you wouldn't mind, beginning tonight by offering us a perspective on how the founders thought about the Constitution, why they created it, and what was their intention in doing so.
Well, thank you so much for those kind words. So, you know, typically when people say the founders thought that, whatever is coming after that sentence is hogwash, because the founders agreed on so little, which is good. Lots of opinions, lots of rowdy voices is very much the American way. But one of the things that they did agree upon was that the spirit of innovation and reform, that you tried to create something, and if it didn't work, you tried something else. And so the first Constitution in the United States was actually the Articles of Confederation. It was passed during the war. It was very much a response away from kingly power in that it had one Congress without really an executive, and you had to have unanimous decisions to change anything. I don't think Congress could come to a unanimous decision today. They certainly couldn't back in, the 1770s and 1780s, and so this document didn't work, and they recognized pretty quickly that it didn't work. And so just a couple of years after the end of the Revolution, the delegates came together in Philadelphia at the Constitutional Convention to create a new document, a second attempt. And they really saw it as a hodgepodge of compromises. You know, when Washington left the Constitutional Convention, he wrote to his friend Benjamin Harrison, and he said, it was the best that could be had at the moment, and it leaves the door open to amendment by future generations. This is not saying like this is a a wisdom handed down from high above the thing that's, carved into stone. It was the best we could have. It was a series of compromises. We know that there are problems that we did not fix. They knew slavery was the subject they were sweeping under the rug. And they desperately hoped that it would be enough to get future generations to a point where they could come up with more creative solutions than they had been able to think of. So it was very much a stepping stone for future generations. They didn't see it as perfect. And the minute they saw loopholes in it, whether it was a lack of a Bill of Rights, a loophole in how you elected a president such that you could have a tie, they fixed it through amendment. And so they put forth a spirit of innovation, and then they lived that spirit of innovation themselves.
That's a great place to begin. Professor, we'll turn to you. Can you answer your own question? If you had a student in your class right now, and they asked you, how do I read the Constitution? We're not in the founding times, we're in modern times. How should we try to read the Constitution today, in your view?
Well, first of all, thanks for having me. It's a tremendous honor. But in response to Lindsay's point about, things being set in stone, you think of the 10 Commandments, but we could all interpret that lots of different ways, right? Bible passages, poetry. There's lots of ways of construing ambiguous language. It's an old document. It's pretty short. And I find increasingly with students, disabusing them of the idea that there's one way to read it, there's a right way and a wrong way. Takes weeks in our polarized culture for them to get this idea that judge is judge. There's a discretion element there. The Constitution is very difficult to amend. It's been a long time since it's been amended, only 27 times. And so when the Supreme Court interprets something like equal protection or due process or reasonable search or free speech, and reverses precedent, establishes a multi-factor test, that functions in a way like an amendment until there is a new configuration on the court, or there is an actual constitutional amendment, which the democratic process takes supermajorities in both houses of Congress and in the states. So I explained to them that if you understand the why, it's all my books, you mentioned the why. If you understand the why behind the Constitution, you can kind of noodle yourself towards the what. And we don't always agree on what the why is, right? One of the things we talk about is who gets to decide. Is it the states? Do the states represent the people? Is there some kind of power lodged in individuals that you're not a member of the state? Of course, the founding generation rejected a monarchy. If you've seen Hamilton the musical, or I'm dating myself, Schoolhouse Rock in the 1970s, it's no more kings. You don't have to have gone to law school. Kind of imagine it like a triangle. If you have this, monarchy that the Revolutionary era sort of threw off the yoke of monarchy. The idea is the power comes from the divine right of kings. That triangle was flipped upside down, and the power's in the people, and it trickles down to the elected representatives. But of course, it's really messy. It's a pluralistic society. People have different points of view. You have to make compromises. There's winners and losers. I think we lose sight of that these days. That most foundational idea, that concentration of power in one place is what is the antithesis of what all of those years were designed to avoid.
Let's dig into that idea of power and how it's concentrated. Before I even got to meet Congressman Raskin, I was at the Washington Post and I heard about him. And he was someone I was told from multiple sources was always advising the leadership and the speaker on constitutional issues. And he was thinking through, even years ago when he was first elected, how Congress should navigate the Constitution. How do you see, Congressman, the role of the Constitution in your own life as a practitioner of politics, as an elected member of Congress? And you're often asked, I know by your constituents and others, is Congress a so-called co-equal branch? How do you answer such a question?
Well, Robert, thank you for your kind words and for the question. And Lindsay, thank you for inviting us here. And hello to all the beautiful Mount Vernon people here. And well, let's see. I think you cut me to the quick here because I reject that sixth grade dogma. I'm sure Ms. O'Connor and Mr. Curtin don't do this. But I reject the sixth grade dogma that we have three co-equal branches. First of all, co-equal is not even a word, okay? That's the first problem with that. The second is, if you look at the design of the Constitution, you look at the structure of the Constitution, so you've got the mission statement, right? So you've got the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and preserve to ourselves and our posterity the blessings of liberty, do hereby ordain and establish the Constitution of the United States. The very next sentence is the first sentence of Article 1. It says, all legislative power is vested in a Congress of the United States. So the sovereign power of the people to create the Constitution, to author the country, really flowed immediately into Congress. Then you get page after page after page of all the powers of Congress. We've got the power to declare war. You don't have the power to declare war because you're president, or you're Tulsi Gabbard, or you're on the Signal chat group. That's not how war gets declared. War gets declared by the representatives of the people because the framers of the Constitution, and here I will speak in general for pretty much all of them, believed that the question of war and peace, life and death, was way too serious to vest in one person because the kings had plunged their countries into wars of conceit and vanity and avarice and greed and fame and all of those things. And they said it should belong to the people. We've got the power to impose taxes and tariffs, not the president, which is why President Trump's tariffs have been struck down by the Court of International Trade, struck down in the Federal Circuit, Court for the Federal Circuit. No president had ever attempted that before, again, because the power of taxation belongs with Congress. The power of the purse belongs with Congress. So we appropriate money. The president either signs it into law or vetoes it, and we could override the veto. But in any event, once it's law, the president has one job, which is to spend the money we've told him to spend, not to impound it, not to rechannel it, not to rescind it or redirect it, because we are the representatives of the people. So anyway, you go through all that stuff. You get to Article 1, Section 8, Clause 18, and all other powers necessary and proper to the execution of the foregoing powers. Then you get to Article 2, which is like this big. And
you can see it in the document up there.
it's right out there, yeah. And the main paragraph is a president shall be removed from office upon impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. If we are co-equal or equal branches, why do we have the power to impeach, try, convict, remove, and disqualify permanently a president, and he doesn't have the power to impeach, try, convict, remove us, right? I don't accept that idea. I believe that we are the lawmaking power. What's the president's job? Well, if you take away commander-in-chief, because it's not commander-in-chief of the country or the government, it's commander-in-chief if you're a textualist, an originalist, as I am. If you believe that, then he's commander-in-chief of the Army and Navy and the militias in times of actual service. So when there's a war going on, right? It's not like you're walking around as commander-in-chief. So what is the core function of the president? To take care that the laws are faithfully executed. That's it. Not rewritten, not revised, not improvised, not reduced, thrown away, improved, whatever. Take care that the laws are faithfully executed. So I'd say the people are sovereign here, and the people's representatives are, as Madison put it in the Federalist Papers, the preeminent branch.
Whether a compelling case, whether you agree with the congressman or not. Judge, Lindsay referenced at the beginning of her remarks your reputation in the legal community and the country. Help us understand how that reputation came to be in the sense of your perspective on the Constitution. You're a young lawyer. You go to work in the Justice Department, the White House. You become a judge, a very high-profile judge on the federal level in the highest courts. What was your engagement in view of the Constitution when you started, and what formed your position, shall we say, on the Constitution. So many conservatives cite you when it comes to legal issues. How do we understand, for us non-lawyers, how you see the Constitution and the law?
And there are liberals who cite him too, like me. So, yeah.
Me too.
Well, thanks, Bob. And first off, since I am appearing here as a former judge, everything that the congressman said, it is so ordered. But second and most important of all, thank you so much for this evening. And this presidential library. What a privilege it is for all of us to be here on the grounds of Mount Vernon, under the auspices of the President George Washington's library, honoring our first President of the United States, honoring our Constitution of the United States, and honoring the teachers and professors across the land who teach our youth and our adults about the first president and about the Constitution of the United States. And last, but first, as we came in here tonight, we all stopped by to look at the Constitution that's on display. I began to shake just a little, just thinking about being in the presence of the Constitution of the United States. My voice just broke saying that. It's not my place to thank whoever the donor was, whoever made that Constitution available for us tonight, but whoever it is, thank you on behalf of America. It's a privilege. So, Bob, we don't want to spend any time on how I came to be what I am. That's of little relevance. But I will say this. I had the opportunity and the privilege very, very early in life, right out of college, to work in the Ford White House, Gerald Ford White House. I was there for 3 months, and I got an opportunity to go to the Supreme Court and work for the Chief Justice of the United States in an administrative capacity. And I did so. I called my dad first and said, what should I do? The White House is a pretty exciting place. And he said, son, everything you've ever believed in life is at the other end of Pennsylvania Avenue. And so I went there, became fast friends with the Chief Justice, worked for him for 2 years, then left and went to law school. After law school, I was going to clerk because I only wanted to be a judge, and I got a call from President Reagan's new White House counsel, Fred Fielding, the day of the president's inauguration. He said, would you come up and interview with me next week? I'd like for you to be in the counsel's office. I did. I went to that counsel's office under Fred Fielding, who was the White House counsel of all White House counsels. And then when the president nominated Antonin Scalia to the D.C. Circuit, I went with him because that's what I wanted to do in all of life. Worked for him a year, and then went back to the Chief Justice as a lawyer and clerked with him, and then remained with him for several years as what he called special assistant to the Chief Justice. All of that is long-winded to say this. The reason I'm sitting here today, I believe, is because of humility. I think humility is the most important characteristic, character quality that one can have. And by humility, I mean this. And I gave a quote one day to someone who asked me the same question Bob did. And I said, look, I go into every single room, every single meeting, assuming that I don't know the answer. And I listen to every person carefully and attentively. And then invariably, we walk out together knowing the answer. And it was never the answer that I went in with or that they went in with. If we had that in America today, America would not be in the constitutional crisis it is today. Then turning to the substance of Bob's question, it's this, and we were talking about this on the way over, the professor and I. I'm a conservative. I'm a proud conservative, particularly a proud legal conservative. That has always, up until today, meant one thing, one body of principles and thinking about the law and about the Constitution of the United States. No longer. Whatever is being passed out as conservative legal thought today, I don't recognize. Someone asked me last week, well, what would I call it? I said, it's radical. It's not conservative, it's not liberal, it's not, centrist, it's radical. I learned at the hands of the masters conservative legal thought, legal reasoning, and legal methods. The congressman mentioned just two of them in originalism and textualism. Those are self-evident, to you what they are. I was never an originalist, but I was always a textualist and what's called as a strict constructionist. But again, for purposes of tonight, that's all that matters about me. At the larger level, what matters is what I told you before. Everything that you've heard for the past 4 years coming from the right, the Republicans, and the conservatives is unrecognizable as conservative legal thought. And incidentally, and I get out of my lane here, and I'm sure that Bob will bring me back in.
Good luck
Nothing
to me.
that you nothing that you see and hear for the past 4 years is conservative politics either.
The judge The judge used a phrase in his remarks that was the part of a CBS Sunday morning piece at the beginning of this year. We asked the question, what is a constitutional crisis? You used that phrase, constitutional crisis. And President Trump, whether you're a major supporter of his or a harsh critic, he is certainly comfortable with the use of executive power. I spoke to him on Sunday, actually, ahead of Face the Nation on CBS, and I've never seen him, as someone who's covered him for 15 years, more at ease with power. He is moving on all fronts with total ease and confidence that he can do what he is doing. Lindsay, let's come back to you. I was speaking to a historian here, Tom Soaps, a friend of mine, before this discussion, and he had a good question about the historical context that I think you can help us as we get into this topic, a constitutional crisis or not. Is what is happening now with President Trump and the Trump administration somehow different, or is it just another tense moment in a nation where there is a history of tense moments? How do you understand it, not as a lawyer, but as someone who loves history, a historian?
Yeah, it's a great question. So, we have certainly had moments of constitutional crisis before. I put the first one in the election of 1800 and 1801. There was, of course, a tie in the Electoral College, and it wasn't clear that the Constitution was going to provide a way out of that logjam, which is sort of the definition of a constitutional crisis. You're not sure that the Constitution can solve this problem. We have had, many others. The Civil War was a massive 4-year constitutional crisis. I think we have seen others as well. What I think is so notable about that first one, and is perhaps instructive in this moment, is they very much understood they were living through a historic moment. They were seeing whether or not the Constitution could withstand the threats. The threat of violence was real and palpable. There was a mob outside of the Capitol building threatening to kill anyone who tried to take the presidency from Jefferson. The Pennsylvania and Virginia militias were stationed on the border, ready to march in if the Federalists called another election. And what got us through that moment was, I think, 2 key things. One, John Adams, the president at the time, practiced something we very rarely celebrate in presidents, which is restraint. As he looked at the Constitution and he said, I actually have no role in this crisis. This is entirely, to the congressman's point, a congressional power. And any activity he might have would be, even if very well-intentioned, outside the bounds of the Constitution. And so he did not take public action. He did invite the vice president at the time, Thomas Jefferson, to the White House and expressed his belief that Jefferson was the rightful winner, that he would ultimately be the people's choice. Adams swore he would play no role in a future election or in any sort of Federalist schemes, and he would critically support the transition once the vote had been decided. So that was part one. Part two, the participants didn't know the outcome, but they understood how fragile the republic was. They had skin in the game because most of them had either fought in the war or had been in a revolutionary government. And they were willing to compromise to put the Constitution and the survival of the republic above their own political or partisan interests. Very few people got what they wanted out of the outcome. They got survival. In this particular moment, we don't know the outcome. We don't know if the Constitution provides the mechanisms for which we can manage the current threats to the rule of law and the things that we are seeing. But I think what, for me, is instructive about the past moments of constitutional crisis, Watergate is another great example. It was Republicans who said to President Nixon, you have to go. It was Republicans who put the Constitution and the good of the nation above their own partisan interests. And part of the story that's not often told about that is they won a landslide election in 1980, just a few years later. So I do believe that the American people will reward that kind of behavior. And so I think those 2 moments are instructive for what we can hope for in this moment, what we can encourage, and what we can demand.
Congressman, what's your answer to the question about whether we are in a constitutional crisis or not? You are in the fight as much as anyone inside Congress. And if your answer is in any way yes, help us also understand, why are there no marches in the street? I mean, I know there were mass rallies earlier this year in different capacities, but explain the country's response or lack thereof if there is a crisis.
I believe we are clearly in a constitutional crisis, but that's to say the least of it. The Constitution's under attack systematically. Every part of the Constitution, the powers of Congress are under attack, the powers of the judiciary are under attack, the rights of the people are under attack, the freedom of speech, the freedom of assembly, the freedom of press, the right to petition government, due process, the 2 most beautiful words in the English language, certainly the 2 most beautiful words in the Constitution, which separate all of our freedoms and rights from the arbitrary power of the states. I had a debate on the floor a few weeks ago about due process. One of my colleagues said, well, you're not saying you believe in due process for guilty people, are you? And I said, well, that's the whole point, right? We don't know if they're guilty until there's been due process, But so I would say the Constitution is under attack. And, I believe actually we're seeing massive outcry in the country. I mean, the last No Kings rally were the largest protests in American history. And for those of you interested, they're coming up again on October 18th. I'm sure George Washington would be there. Look what just happened with Jimmy Kimmel, massive manifestation of public sentiment that the president cannot be appointing or firing comedians on public, on news broadcast channels. And some people say, well, that's just comedy. Comedy's comedy. But you know what? Comedy's pretty serious business, because it is the late night comedians who've kept a lot of people's hopes alive during this very dark period, because it is the comedians who tell us through their humor not to be afraid. And one of the things that American constitutional democracy and our First Amendment established is that people have a right to make fun of their elected officials. Because those of us who aspire and attain to public office, whether it's elective or appointive or whatever it would be, are nothing but the servants of the people. And the moment that one of your public officials begins to act like a king, a lord, an emperor, a dictator, that is the moment to evict, eject, reject, impeach, try, convict, diselect, start all over again. Because in America, our elected officials work for us, and the people are always sovereign. And those are the three most important words in the Constitution: we the people.
Can I pop in real quick? Sure. So I love what you said about people have the right to make fun of public officials. In 1793, George Washington started to get a lot of criticism in the newspaper around his French policy, and the French minister in particular. And one newspaper editor just printed lies, just outright lies about the president. And Washington had initially subscribed to that newspaper because he loved newspapers. He was a bit of a newspaper junkie. And he canceled his subscription. And the newspaper editor continued to deliver 3 copies to the president's house every day just to annoy him, just to make him mad. And it worked. He complained in private, in cabinet meetings. He would lose his temper and say that they were doing it just to get under his skin, which they were. But he never said anything publicly, because he believed in, of course, the right of people to criticize him. He believed that it was beneath his office because he was the most powerful person, and he was so respected and vaunted in the American imagination that to come down on one editor would be inappropriate. And so, that is one of so many precedents that he established that we, I think, have to cherish.
And the presidents are still getting mad, but now they're not getting mad about people telling lies. It's about telling the truth about them. But
That's often more painful, right?
You have a right to tell the truth under the First Amendment, too.
Professor, you've written a terrific book about presidential pardons, and you have studied and taught on presidential power, the Constitution, for years. What's your assessment of President Trump and presidential power at this time from your own constitutional prism?
I've come to believe it's mostly about psychology. There are rules, there are speed limits in the street, but we'll speed until we get a ticket. I have 4 kids. If there's a rule to not eat on the couch, but you let them do it on the Super Bowl, there's no rule anymore. And the question right now is, where are the tickets for speeding in the White House? Congress, I think, the Republicans in Congress have abdicated their prerogative that the congressman laid out, the various powers under Article 1. They're not insisting on them. They're ceding them to the president. The United States Supreme Court is not holding the president accountable under plain language of the Constitution, established precedent in these eclipsed, quick and dirty, 1-paragraph orders that evade the press because they're so difficult to unpack unless you have some expertise in it. So, and we also, the country elected someone who's made it clear he doesn't respect the rule of law. That was crystal clear. Arguably, people voted for him because of that. And I think what we're seeing in this moment is how a lot of our law is respect for the rule of law. People call it norms. It's the idea that I'm going to follow it because I believe in it. That was not his platform. He sees not only the play in the joints, the ambiguous parts, that there was no law made because no one needed to make law, but even the things that are clear, he's crossing those boundaries and saying, who's going to stop me? Right? Is impeachment meaningful? Is the Supreme Court meaningful? Are oversight hearings that we can ignore subpoenas and we can lie meaningful? Elections, are still there. Protests, as it was indicated. But the levers of power as they're supposed to function aren't, and that's in my mind where there's a constitutional crisis, where things that are bedrock principles, First Amendment, due process, these things, they're being violated and there's no pushback. And I think many Americans are like, whoa, what do we do about this? And I would add a couple other things. One point, to your point about Watergate, I was in the BBC Green Room many years ago, and there was a member of the Republican Party in the House of Representatives who was one of the first to go to President Nixon and tell him that it was over. And he said, we had CBS, ABC, NBC, and the Washington Post and the New York Times. Americans got one message, and we could collectively decide what to do based on our value system and a single set of facts. Now, corporations are making record billions off of taking our data for free, and everybody in this room gets a different news feed based on the algorithm's perception of what our biases are. And we don't even know what the algorithms are. And bad news travels multiple times faster, lies travel faster than truth. And in addition, at the time of the founding, there wasn't this robust corporate culture. Corporations existed, but there wasn't a lot of tax breaks for them. And there certainly weren't these large ones that have been declared to have First Amendment rights, like living, breathing people with Social Security numbers and birth certificates, right? So they can put a lot of money into elections under the guise of free speech, that is, through advertising. I think that force, and on the S&P, a big percentage of them make a lot of money through the hate that is spread on social media. So I think that's another element that maybe wasn't there in the 1970s, where we had a set of facts that, I remember growing up in Buffalo, one of 5 kids, it was hard to find information. You had to go to the microfiche. My mom got a new, at the Super Duper supermarket, she'd get another volume of the encyclopedia if she spent enough money, on cereal or whatever, and that's what we used for our book reports. Now it's a matter of sorting information. How do you find accurate information? And I know from my students, our attention spans are short. It's hard to get students to even read. So I think I agree we're in a constitutional crisis because it's not being enforced, and the question is how to enforce it in this moment. But it's complicated, I think, by things that have arisen in the digital age and through decisions by the Supreme Court, not Judge Luttig's decisions, of course, but he knows more about these than probably anyone else in the room. I think those two factors make it a unique moment in American history. So when people say, oh, we've been here before, I think that's naive and it's a bit dangerous.
Let's turn to the Supreme Court, and then we'll get to some of your questions from the audience here. When I'm on Capitol Hill and I'm talking to Republicans and some Democrats, they often wonder about the Supreme Court. What if the judge was put on the Supreme Court by President George W. Bush 20 years ago? And he came so close, and so many to this day on the right and elsewhere really wonder how the court in America would now be different if the judge had ended up on the Supreme Court, had a storied career in the federal courts and as a conservative thinker and leader till this day. You mentioned traffic tickets, Professor. The Supreme Court ultimately decides how to understand the Constitution. This is a bit in the weeds, but I think it's important for you to guide us on this particular point. We're all looking as citizens to the Supreme Court for clarity on constitutional questions. And often, citizens and journalists and others expect the clarity to come through what are called written opinions. Written opinions, however, don't seem to be the norm on all of these constitutional questions. Instead, we're seeing what are called orders from the Supreme Court, almost terse statements or responses to some of these core questions. what is your take on what is happening on the highest court when it comes to the Constitution, their responsibility, and how should we understand what is happening in terms of how they're looking at presidential power and what President Trump is doing?
The Supreme Court has squandered almost its entire legitimacy in the past 9 months since Donald Trump came back to office. For this reason, the court has decided many of the most important issues that could ever be decided under the Constitution of the United States through what is called now the shadow docket. All you have to know about the shadow docket is this. The major opinions that come up from the lower courts for decision on every one of Donald Trump's initiatives. Incidentally, I wrote an article for The Atlantic on his first 100 days, discussed every one of his signature initiatives, 10 or 12, every single one of them palpably unconstitutional or otherwise clearly in violation of the laws. As those cases have made their way up to the Supreme Court, with few exceptions, if any, the lower courts, federal district and court of appeals, have struck down what Donald Trump did. When the case, as soon as the lower court decides against Donald Trump goes to the Supreme Court on an emergency basis and says, there's an emergency. You have to decide this case now. The Supreme Court has done it 10 or 12 times.
22.
22. But here's all you need to know. Without one single word of explanation or reasoning under the Constitution of the United States, not by written opinion, by order, not one word of explanation, over 30, 40, 50-page dissents by the three other members of the Supreme Court of the United States. The court has acted illegitimately under that shadow docket, and the American people should not tolerate it. And the Supreme Court has been as arrogant about it as I've ever seen the court be as to anything in all of American history. It has said to the American people, we will rule by edict. That is, by raw power. We have no obligation to explain ourselves to you, the American people, or to anyone else. That's a crisis in and of itself. Bob rightly says that we look to the court for clarity. It's not even that complex. We just look to the Supreme Court for a reasoned answer, period. And this Supreme Court has refused to give us that. The entire the only power that the Supreme Court has under the Constitution of the United States is in its judgments. Judgments. That's its opinions. Judgments, though, think of the word judgment. It subsumes reasoning and judgment on the Constitution. When the Supreme Court is not issuing judgments, and instead exercising only raw power, of which it has zero raw power, it's illegitimate.
Thank you, Judge. We're going to turn to some of the audience questions for the final few minutes here. The most sought question here appears to be this. Other than impeachment, did the framers of the Constitution build in any mechanism to prevent an autocratic leader from subverting democracy? Congressman?
This is a great question. Who asked that one?
Tom.
A bunch of you did, yeah.
This is going to be on C-SPAN, so I won't give his last name. Tom.
The whole Constitution is designed around the division and the distribution of powers. They understood with Lord Acton that power corrupts and absolute power corrupts absolutely. And so you can view the Constitution as a series of separations of power, not just legislative, judicial, executive, but the separation of powers between the national government and the states. And then the states and the political subdivisions, the counties and the cities and the towns, between the government and the people with the freedoms of speech and press, the fourth estate, which is, what keeps people honest. But let me delve into one of them. The separation of church and state goes right to your question, because look, what was the genius breakthrough of the American Constitution? It was the separation of church and state. For centuries, there had been religious warfare between the Catholics and the Protestants in Europe, every bit as vicious as the wars between the Shia and the Sunni today in the Muslim world. There had been inquisitions, crusades, government-run churches, and church-run governments, complete union of church and state. The separation of church and state is a great protector of freedom and liberty in America against tyranny. And those who strive towards tyranny always want to abolish the separation of church and state, blend it, bring it back together to make theology and religious practices part of some kind of secular program. I mean, one of my colleagues got up on the floor not long ago in the House. He said, the moral downfall of America was in 1962 in Engel versus Vitale, when the Supreme Court banned prayer in the public schools. And I got up and I said, the Supreme Court never banned prayer in the public schools. As long as there are pop math quizzes, there will be prayer in the public schools, okay? Anybody can pray whenever he or she wants to pray. What the Supreme Court found was that the government can't write a script and compel your children to participate in it. You talked about the 10 Commandments. You saw a couple months ago, Louisiana and Texas both voted to endorse the 10 Commandments and to post the 10 Commandments in every classroom in their state. I knew it was going to happen. My colleagues across the aisle came in. They said, we've got to endorse the 10 Commandments. We've got to post the 10 Commandments. And I'm like, gee, the 10 Commandments have been doing fine for millennia without an endorsement by the U.S. House of Representatives or the Freedom Caucus. No, one guy says to me, the 10 Commandments are the basis for the Bill of Rights. And I was kind of confused. I was like, well, I know there's 10 in each one, and but let's take a test case, right? The first commandment says, thou shalt have no other God before me. The First Amendment says, Congress shall make no law respecting an establishment of religion, nor prohibiting the free exercise thereof. How does that one dictate that one? But they insist we go up to the Rules Committee. I say to my friend Jim McGovern, they want an up or down vote on the 10 Commandments. I said, you know what? If we're going to vote on the 10 Commandments in 2025, we should have to vote on each commandment separately, okay? Not the omnibus package they're trying to get away with here. And you shouldn't be able to vote for any commandment you yourself have ever violated, okay? Because you'll be taking the name of the Lord in vain. But in any event, the Christian nationalism was one of the major influences in what took place on January 6th. In terms of mobilizing the crowd, the mob, to get behind the Proud Boys and the Oath Keepers in the attempted violent insurrection. So when you see people who are trying to erode and undermine the separation of church and state, somebody has a pretty theocratic and pretty monarchical or dictatorial program going on there.
Can I jump in there for just one point? Which is, I think, there's impeachment, but we can't finish this conversation without talking about the decision last summer in June called Trump versus United States, where the Supreme Court manufactured criminal immunity for presidents. Before that, in the Watergate era, there was an expectation that the president was not above the law. And so again, if you talk about incentives and disincentives in psychology, if you're sitting in the Oval Office, you've got powers no one else does. Do I press the button? Do I cross the boundary? We all say, well, I don't want to do that because something could happen, including a criminal indictment. And this Supreme Court has lifted that for all intents and purposes, and that so long as it's official power, the really scary stuff, the really heavy-duty stuff that can actually strip people of their liberties, then he's above the law. And I think that's probably a before and after moment to some degree when it comes to holding presidents accountable.
As long as we're making addendums, the most important addendum that we should make is Section 3 of the 14th Amendment. That's of immediate importance and significance, as you all know. and as the
Explain that for
Congressman
those who
knows.
don't.
So
Anyone
that
who
was-
has sworn an oath to support the Constitution who violates the oath by, quote, engaging in insurrection or rebellion shall never be allowed to hold federal or state office again.
And so, as the Congressman said, Donald Trump was, he was prosecuted for essentially engaging in an insurrection against the Constitution of the United States on January 6th. And myself, Professor Tribe, the great Professor Tribe from Harvard, and the Congressman and many others, led the argument that Donald Trump, for that reason, was disqualified from ever holding office again under Section 3 of the 14th Amendment. There was just no question of any kind at all. The Supreme Court of the United States just refused to decide the case.
Well, Colorado banned him from the ballot.
Yes.
You exercising their control over ballot access. Trump appealed it to the Supreme Court, and the Supreme Court not only overruled Colorado in their control over their own ballot, but it said they were not going to decide it. They were going to leave it to Congress, but if Congress got it wrong, then it would come back to them. So it did seem like a three-card Monte kind of decision by the Supreme Court.
I should say there is one piece of this, to go back to the question, elections. Elections are the main form of recourse. And it goes back to the power of the people. And they are every 2 years for the House, which is, of course, supposed to be the people's body, every 6 years for the Senate, and every 4 years for the president. So we often think our vote doesn't matter, and there are a lot of efforts to dilute it, to be sure. But as long as there are elections, that is still an important part of the story.
Speaking of elections, and this is referenced in a few of these questions, if it's 2028, President Trump, or even Republicans just themselves decide to pursue another nomination for him in 2028, what happens?
George Washington would like a word.
Well, that actually was one of President Washington's great commitments, of course, which was civilian control of the military, but also peaceful transfer of power, which we saw come under attack, but also respect for the Constitution and fidelity to the law. It's very clear, the Constitution is very clear that you can only serve 2 terms in office. And so that should be the end of the story, but as...
But if he's nominated by the Republican Party, which is not a constitutional process, it's a political party nomination, and he's somehow put on the ballots in states...
Right. Well, that's why that Colorado decision is so scary, I think. And Judge Luttig's point is right, which is if you don't stick with fidelity to the law, everything becomes malleable and plastic. And I mean, that is one of the clearest things in the Constitution. Like, you've got to be 35 years old to run for president, and you can only serve 2 terms for president. So I think we've got to stand by that Constitution. If you want to change the Constitution, by all means, 2/3 vote in the House, 2/3 vote in the Senate, 3/4 of the state is how you amend the Constitution. But
Lindsay and Bob, I was recently asked to write a long piece on whether Donald Trump would run for a third term, notwithstanding the constitutional bar. And I've already written the piece, and in that piece I say that, almost a quote, that Donald Trump has given the American people every reason to believe that he will run for election again, and he's given the American people no reason whatsoever to believe that he will not.
What does the court do, Judge, in that situation?
Well, I'm asked these kind of, I used to call them esoteric questions, but I don't call them that anymore.
I know it's a bit unfair to ask you to predict anything, but I'm just curious.
Well, I don't have any trouble predicting this Supreme Court, Bob. But I'll cast it this way to protect myself. Under the classic jurisprudence of the Supreme Court, they would hold that question was a political question not to be decided by the court, which is exactly what I said the court would have done. I said this to Congress, the court would have done if the issue of the election in 2020 had made its way to the court. The Supreme Court would have said that's a political question. That's why I testified before Congress that had Mike Pence thrown the election, to Donald Trump on January 6th, that the nation would have been catapulted into a paralyzing constitutional crisis for the first time in history. And the paralysis point there was that literally the Constitution doesn't provide an answer as to how that issue would have been resolved if Mike Pence on January 6th would have refused to count all the votes and declared Donald Trump the President of the United States.
And let it be noted for history that when then Vice President Mike Pence made the decision to not walk away and to not cause chaos on January 6, 2021, he wrote a letter explaining his decision, and in that letter, who did he cite? The judge. We're going to close here. The top question, and if you could all answer briefly, I know people need to go home, and we appreciate you staying here for this conversation. But this is a question that's on the top of everyone's mind, it seems, in this audience, at least based on this iPad. What can citizens do right now to preserve and protect the Constitution? And we'll begin with Lindsay and go down the line.
So I think a lot of people feel helpless and hopeless. Apathy needs to be the enemy. And so that can mean a bunch of things. Reach out to congressmen who you feel are doing the right thing. They need support. As much as if you disagree with someone, yes, tell them too. But if you feel that your congressman is doing the right thing, they need to know that too. If there is a business that you feel is making a good decision, not just for their stakeholders, but also for the good of the nation, support them with your dollars. Vice versa, if you believe that a business is not putting the good of the nation above its own bottom line, withdraw your dollars. Collect, each person might not have that much impact, but collectively, it is enormous. And so, when I was thinking as we were talking about this, I know I'm supposed to be short, but as we were talking about this, question about 2 terms, and historians are terrible future predictors. But I have to believe that there is still hope that something that is so fundamentally clear will hold true. And so, hope is not an absence of fear. Hope is a willingness to keep going anyway. And that is what every person can do.
Congressman?
So, yeah, when I was a kid, my dad used to say to us, when everything looks hopeless, you're the hope. So I think I'm looking at the hope. And I just finished reading Navalny's book. I don't know if any of you guys have read Patriot. It's an awesome book. But in it, one of the things he says that moves me so much is, because I could never really get over the fact that he went back to Russia after everything, and he went back, but out of just a profound love of his country. But he said, the thing that will trouble the liars the most is if everyone goes and tells the truth. If everyone tells the truth, then a system of lies and deceit cannot be sustained. And each one of us can do it, no matter where we are. And in an authoritarian crackdown in society, every part of society is affected. The colleges, the universities, the high schools, the corporations, the workplaces, the courts, every place is affected, and that means that everybody has the opportunity to tell the truth, which is what the liars fear most. And we really have nothing to be afraid of. Navalny was very emphatic about that. He said, and I think we should say too, this is our country, this is our Constitution, this is our Bill of Rights, and we're going to defend it and protect it with everything that we've got, and we are the vast majority in the country, and there is really nothing for us to be afraid of, or as Roosevelt put it, there's nothing to fear but fear itself. We can get over that, as you say, Lindsay. We can act with hope and courage to pass on to our posterity the blessings of liberty.
Professor.
You know, the Constitution itself was miraculous. It wasn't in any way inevitable. Throwing off the yoke of a monarchy, this colony, right, and then surviving despotism and fascism in the early 20th century. You know, I don't think there's an obvious answer in the structure of the Constitution and the traditional levers of power in this moment, but I do agree with what others said, that collective action and energy around this will produce some kind of magic. We don't know what that will be, but what does that mean for everyone here? It means take one thing from this conversation and share it with one person. Do one thing every day, whether it's speaking out, whether it's supporting people who speak out, making a phone call to a member of Congress, you know, educating some kids about this. You know, young people, I talked to hundreds of them, they feel disillusioned. They don't think their vote matters. They're looking for guidance. They're looking for leadership. They're looking for energy. And you know, spreading this idea that just like you hang on to your 2-year-old's hand when you cross the street, even if they're in a temper tantrum, like we all have to hold the hand of democracy and the Constitution in this moment. And I believe if we do that, again, it'll percolate in a way that will have a tremendous impact. We cannot expect, you know, people like Congressman Raskin, who I would say is an American hero, among others, to hold the torch for us. We all have to care. But it doesn't take a lot. You don't have to start a protest. You don't have to start a nonprofit. But every day do one thing, and if everybody did that, I think we would see our way through this. I do.
Thank you, Professor. Judge?
If this nation is any longer to endure, it will require that the Congress of the United States take back the power that it has surrendered to the president, as well as the power that the president has arrogated from the Congress of the United States.
A round of applause for this panel. Dr. Lindsay Chervinsky, Congressman Raskin, Professor Wehle, and Judge Luttig. Thank you very much for coming tonight.
And thank you to our moderator.
Thank you,
No
Robert.
easy task. No easy task. Can we do a photo?
Awesome job, Judge Luttig. That's beautiful.
Thank you.